Hi guys, welcome to this very important session, part 2 of Legal Aptitude Analysis. So first of all, I would like to wish all of you a very happy Ram Navami. But even on this particular day, we are going to learn certain important legal aptitude questions because learning is not going to stop even today, right? Uh, so please give me a very quick tech check in the chat window if you guys can hear my voice and look at the screen properly so that I will actually proceed with the class, right? Okay. So today we are going to discuss, this is the second part of analysis. Yesterday we discussed, shift 1 question paper of 3-year LLB. And today we are going to talk about shift 1 question paper. There's only one shift in 5-year. So we are going to, discuss this particular paper in today's class, right? Very good. I think good afternoon, Alpha. Good afternoon, Soundarya. So let's proceed, guys. Let's proceed with the questions. Question number 1. Which of the following amended preamble to the Constitution of India? Which of the following has amended preamble to the Constitution of India? Please write your answers in the chat window. Very good guys. Very good Alpha, very good Nidhi. So the answer is 42nd constitutional amendment. Sorry. Yeah. To make it a little thinner. Yes, guys. Here it is. 42nd constitutional amendment. Correct. Very good. Nidhi, Madhavi, Nayak, everyone has got this right. So in the original preamble, certain words were not used, right? So for example, the word socialist, the word secular, and the word integrity. Right, I think integrity is coming back of my head, but that's not a problem. Just note down these three words. These three words were not mentioned in the original preamble. By enacting 42nd Amendment, socialist and secular were added as adjectives to the word republic, right? So earlier India was a sovereign and democratic republic. Then we made as sovereign, socialist, secular and democratic republic. Whereas with respect to integrity, there it was written as unity of India. Here we change it as unity and integrity of India. So 42nd Amendment is the right answer. If you look at other options, 27 is not really important, 40th is also not important, but 44th Amendment is also important. So what is the significance of 44th Constitutional Amendment? Can somebody answer it down in the chat window? What is the significance of 44th Constitutional Amendment? Okay. So by enacting 44th Constitutional Amendments, many provisions of 42nd Amendment were nullified. The primary one being, right to property, right? So right to property was removed as a fundamental right, and now it is placed as a legal right in Article 300A, capital A. Next. Yes, correct. Which part of the Constitution incorporates the concept of welfare state? రాజ్యాంగంలోని ఏ భాగం సంక్షేమ రాష్ట్ర భావనను పొందుపరిచింది? సంక్షేమ రాష్ట్ర భావన, that is the concept of welfare state. We discussed about it in our classes. Okay. Very good, Alpha. Very good, guys. So DPSP, which is in part 4. Yeah, well done. Yes, Nayak, it's 2. So in part 4, DPSP talks about the concept of welfare state, especially if you look at articles 38 and 39, even other articles also, like everything from 38 to till 51, let us say, most of them are talking, but especially the socialist directive principles, they talk about the concept of welfare state, right? State has to ensure the welfare of the citizens. So fundamental rights are there in part 3. Fundamental rights does not talk about the concept of welfare. So fundamental rights are civil and political rights. Sorry, these are fundamental duties. Fundamental duties are there in 4A, so fundamental rights are here, right? So in preamble, it is not mentioned. So this is the right answer. Next. An agreement in restraint of marriage is వివాహం చేసుకోవద్దు అనే ఒప్పందం. So if I'm making an agreement with somebody saying that in the agreement it is written that you should not marry, so then only I'll fulfill the contract. What is the type of contract? So will it be valid or is it voidable, or is it void or it is an enforceable contract? Okay, looks like I'm not getting an answer, so the answer is void, right? So if you make an agreement saying that you should not marry someone and should not marry this particular person, then that is actually not enforceable in a court of law. The agreement is not enforceable in a court of law. So for that matter, it is void. So ante adi sarainadi kaadu, then enforce cheyalem. Okay. Next. Prohibition of traffic in human beings and forced labor comes under which of the following fundamental rights? మనుషుల అక్రమ రవాణా మరియు నిర్బంధ శ్రమదోపిడి నిషేధం ఏ ప్రాథమిక, just a second guys, something important is there. Okay. What is the answer? Well done. So the answer is right against exploitation, right? So under right against exploitation, how many fundamental rights are there? How many fundamental rights are there? There are 2 fundamental rights under right to exploitation. One is 23 and the other one is 24. 23 prohibits the traffic in human being and forced labor, and 24 talks about child labor, prohibition of child labor, right? So when it comes to right to freedom, so right to freedom is there in article 19, right? So from 19 till we can go up to 25 until 24. So all of these are rights to freedom, rights which are there under the freedom. So then we have right to education, right? Right to education is under article 21. Cultural and educational rights are different. So cultural and educational rights are there under 29 and 30. And then we have right to constitutional remedies under article 32. Who has sent this? And they'll confirm by tomorrow. Next. Which amendment act added right to free and compulsory education for children between 6 and 14 years as a fundamental right? ఏ రాజ్యాంగ సవరణ చట్టం 6 మరియు 14 సంవత్సరాల మధ్య వయస్సు గల బాలలకు ఉచిత మరియు నిర్బంధ విద్యను ప్రాథమిక హక్కుగా గుర్తించింది? What do you think is the answer? Yeah, well done. Very good. Well done, Alpha. So 86th amendment which was enacted. Very good, Nazia. Excellent. So 86th amendment which was enacted in the year 2002. Okay. So it has made right to free and compulsory education for children between 6 and 14 years as a fundamental right. Before 86th amendment, what is the position of right to education? Before enacting 86th amendment, అంటే 86వ రాజ్యాంగ సవరణ తీసుకురాక ముందు ఉచిత మరియు నిర్బంధ విద్య యొక్క పొజిషన్ ఏంటిది అసలు? వాట్ ఈస్ దట్? Can I expect some answers? Fundamental right. No, No, it's not before 86 I'm talking about, not after 86. Right. So before enacting 86th constitutional amendment, right? Very good, Alpha, excellent. So before enacting 86th amendment, right to free and compulsory education was a DPSP under Article 45. Okay. So Article 45 lo DPSP lo undi. So very good, Nazia. So then we made as a fundamental right by enacting 86th amendment. So 86th amendment has made 3 changes, right? One in fundamental rights, one in DPSP, one in fundamental duties, right? So originally, and original constitution lo ఉచిత నిర్బంధ విద్య అనేది ఇట్ వాజ్ ఎ డిపిఎస్పి. సో డిపిఎస్పిని మనం తీసుకొచ్చి వీ కెప్ట్ ఇట్ యాజ్ ఎ ఫండమెంటల్ రైట్ అండ్ ఆర్టికల్ 21 క్యాపిటల్ ఏ. మరి డిపిఎస్పిలో ఏం చేంజ్ చేసినాం? వీ మేడ్ డిపిఎస్పి యాజ్ హియర్ ఎర్లీ చైల్డ్హుడ్ కేర్. సో ఎర్లీ చైల్డ్హుడ్ కేర్ ఫర్ చిల్డ్రన్ ఆఫ్ 0 to 6 years. 0 to 6 years మధ్యలో ఉన్న వాళ్ళ చైల్డ్హుడ్ కేర్ని వీ కెప్ట్ అండర్ డిపిఎస్పి. అండ్ అండర్ 51K, okay, we made a fundamental duty to every parent or guardian to make sure that his child or ward is getting 6 to 4 years of 14 years, he is getting this free and compulsory elementary education. It is a duty of the parent or guardian to take care of his ward with respect to this regard, right? So these 3 changes were brought. So for 45 there was a change made, and 51K, right? 51K was added by 86th amendment as well. I hope this is clear. Next. Question number 66. The executive power of the union is vested in which one of the following below? I think I should get some water or something. The executive power of the union is vested in which of the following? Very quickly, guys, it's a very easy question. Okay. Very good, Alpha. Very good, Madhavi. So yesterday also I was making a reference to this, right? So కేంద్రం యొక్క శాసన నిర్వాహక అధికారం రాష్ట్రపతి చేతిలో ఉంటుంది. సో ప్రెసిడెంట్, all executive actions are taken in the name of president, right? Very good. Very good, Ghania. Ghania has joined newly in the chat window. Next. Recently, Government of India proposed to increase the marriageable age of girls to -years. ఇటీవల భారత ప్రభుత్వం ఆడపిల్లల వివాహం చేసుకునే హక్కును ఎన్ని సంవత్సరాలకు పెంచాలని ప్రతిపాదిస్తుంది? Excellent, very good, Alpha, Madhavi, Nidhi, Nazia, Indira. Well done, guys, very good. So the answer is 21 years. This is not enforced yet. Okay, so inka ee 21 years implement cheyaledu, but as of now this is just a proposal. Okay, kevalam oka pratipadana matrame. So what is the current legal age of marriage for men and women, or what is the present legal age? Alpha, it has to be, I'm asking men and women. Correct. So 18 for girls and 21 for men. Very good, guys, very good, excellent. Yeah, well done. Next. 21 for boys, yes, correct. When the offices of both speaker and deputy speaker are vacant, who will appoint the person to perform the duties or functions of speaker? ఒకవేళ స్పీకర్ అండ్ డిప్యూటీ స్పీకర్ లోక్సభ సభాపతి మరియు ఉపసభాపతి ఆఫీసెస్ 2 ఖాళీ ఉంటే ఎవరు స్పీకర్ డ్యూటీస్ పర్ఫామ్ చేయడానికి ఎవరిని అపాయింట్ చేస్తారు? హూ అపాయింట్స్ ఎ పర్సన్ టు లుక్ ఆఫ్టర్ దీస్ డ్యూటీస్? వెల్ డన్ ఆల్ఫా, వెరీ గుడ్ నాజియా. Well done, well done. Very good, Indira. So the answer is president. So generally, after correct, very good, Madhavi and Ghania. So after the constitution of new Lok Sabha, right? So president will appoint someone who is known as pro tem speaker. So there is I think a question was asked in the previous year question with respect to this also. So a pro tem speaker is appointed at the when Lok Sabha is constituted newly, right, after for every 5 years. Appudu speaker and deputy speaker ever undaru. So అందుకని president will appoint one person, that is pro tem speaker, and he will administer oath to all the MPs, and then from there the speaker and Lok Sabha deputy speaker will be elected, right? And along with speaker and deputy speaker, right, there are some other senior members of the house who we call them as panel chairpersons or panel members. So what these people will do is, like, when speaker and deputy speaker, both of them are absent, okay, not vacant, okay, there is a difference between absent and vacant. Absent ki vacant ki teda undi. Absent ante he is there in the his position is there, but he is absent due to some reason, right? So vacant ante position ఖాళీ అయిపోయినట్టు. Absent ఉన్నప్పుడు speaker and deputy speaker ఇద్దరు absent ఉన్నప్పుడు, when both of them are absent, then the panel speaker or panel chairman will come and preside over. So panel chairman are generally the senior members of the house. You might have seen, if you watch the Lok Sabha, sorry, now there is no Lok Sabha TV. So previously there were two TV channels, right? So there was LS TV, which is Lok Sabha, and the other one is RS TV, that is Rajya Sabha TV. Now they have merged both the TVs and they formed it as RS TV or Rajya Sabha television. So sorry, Sansad TV, right? Sansad TV is something where both Lok Sabha and Rajya Sabha proceedings you can witness when they are happening live, right? So if you don't have, just check out this particular channel on your TV. Maybe I'll write. Next, in which of the following cases it was held that 14, 19 and 21, very very important, are not mutually exclusive and jointly aim at reasonableness and fairness? ఏ కేసులో రాజ్యాంగంలోని ఆర్టికల్స్ 14, 19 మరియు 21లో పరస్పర సంబంధం కలిగి సహేతుక మరియు న్యాయం కోసం ఉద్దేశించబడినవి అని పేర్కొనబడినది? Well done, Alpha. Very good. So the answer is Maneka Gandhi versus Union of India. Okay. Look at this particular thing, right? 14, 19 and 21. In Maneka Gandhi case, Supreme Court called this as the concept of golden triangle. Golden triangle, which means this particular triangle is the basic or the fundamental framework of the constitution. If any of these rights are violated, automatically other rights are violated. Like for example, is 19 is violated, then either 21 and 14 will automatically get violated. These three are interlinked, okay? Three of them will together aim to achieve the concept of reasonableness and fairness, right? So just remember this particular thing, and also remember the concept of golden triangle. 14, 19 and 21 are known as golden triangle, as according to the judgment given in Maneka Gandhi case, okay? Ram Swaroop versus Delhi administration is not a really important case, but Golaknath versus state of Punjab in the year 1967, it is a very important case. So after which we got Keshwananda Bharati on 24th April 1973. So Keshwananda Bharati is also a really important case. So there is a question on Keshwananda Bharati in the upcoming slides, so we'll talk about that. On which of the following freedoms can reasonable restrictions be imposed on the grounds of security of state? అంటే రాష్ట్ర భద్రత దృష్ట్యా కింది వాటిలో ఏ స్వేచ్ఛపై సహేతుకమైన ఆంక్షలు విధించవచ్చు? సహేతుకమైన ఆంక్షలు. I think there's some problem in the lighting part of this. Maybe need some correction. Security of state. No, actually. Yeah, of course, everybody is giving a different answer. So the answer is freedom of speech and expression, right? So under to maintain freedom of speech and expression, state can impose reasonable restrictions, on the grounds of security of the state. For other options also, like for example, for other fundamental rights are also limited, based on morality, public order, public health and etc. But for freedom of speech and expression, on ground of maintaining the security of state, it can be imposed. Reasonable restrictions can be imposed. Yeah. A question relating to law of torts, I would say, or constitutional tort. Which of the following cases did Supreme Court rule that the principle of sovereign immunity will not apply to a proceeding for an award of compensation for the violation of fundamental rights? Right. ప్రాథమిక హక్కులను ఉల్లంఘించినందుకు పరిహారం చెల్లింపు ప్రక్రియకు సార్వభౌమాధికారం యొక్క సూత్రం వర్తించదని కింది ఏ కేసులో సుప్రీంకోర్టు తీర్పునిచ్చింది? That's why Rahul went to jail. Who went to jail? Who is Rahul? Yeah. Answer this question, guys. In which of the following cases did Supreme Court rule that the principle of sovereign immunity will not apply to proceeding awarded for compensation of violation of fundamental rights? No, that is a different case, Alpha. So it is not freedom of restriction. It is not even security of the state. It is a private offense. It is defamation. So it's not at all related to freedom of speech and expression. It is related to defamation. Answer this question, guys. Yeah, that's what I understood, that it is Rahul Gandhi, but it is with respect to defamation. Any guess for this question? Right. So the answer is Nilabati Behra versus State of Orissa. See, now what is exactly is the concept of sovereign immunity? So when I was talking in law of torts, we talked whether state, that means union government and state governments, whether they can be summoned or whether a case can be filed against them in a court of law. Right. So when I was talking about it, I talked about sovereign functions and non-sovereign functions. So when I was talking about sovereign functions, I told you that while exercising sovereign functions, will state be liable for the torts committed by its employees while exercising sovereign functions? While exercising sovereign functions, so if you have attended my class on torts and if you remember correctly, you will be able to answer it. While exercising sovereign functions, will the state be liable for the torts committed by its employees? While exercising sovereign functions, the answer is no. Right. So while exercising non-sovereign functions, okay, sovereign functions are like maintaining so accident case was non-sovereign, right? So accident case, he was a driver. He is not in the army, or he is not in the air force, or he is not in the navy. He is not protecting law and order. So anything that is with respect to independence of this country, security of the country, that is known as sovereign function, right? So non-sovereign functions are this one. Yeah, that is not this case. So in Neelabati Behra versus State of Orissa, Supreme Court told that even while exercising sovereign functions, right? So even when you are exercising sovereign functions, if ordinary law is violated, then whether fine will be imposed or not is a different thing. But if while exercising sovereign functions, if the fundamental rights of a citizen are violated, state has to pay compensation. There is no immunity as such. Okay? State ఒకవేళ సావరెన్ ఫంక్షన్ ఎక్సర్సైజ్ చేసేటప్పుడు అంటే వైల్ ప్రొటెక్టింగ్ దిస్ ఒకవేళ ఏదైనా ఒక సిటిజన్ యొక్క ఫండమెంటల్ రైట్స్ వయలేట్ అయితే దాన్ని ఖచ్చితంగా కాంపెన్సేట్ చేయాలి. దేర్ ఇస్ నో ఎక్సెప్షన్ వాట్స్ ఎవర్, రైట్? బట్ వైల్ నాన్ సావరెన్ ఫంక్షన్స్ ఇట్ ఈస్ దేర్. సో దిస్ వాజ్ upheld in Neelabati Behra versus State of Orissa, right? So in Neelabati Behra versus State of Orissa, this is a different case. Neelabati Behra's son, right? Neelabati Behra's son, Suman Behra was there. So he was actually imprisoned. He was a prisoner. He was there in the jail, and in the jail, he was died. He underwent severe injuries and he died. It's a custodial death actually. So in this particular case, Supreme Court asked the state to pay compensation to Neelabati Behra, right? So same, the other cases are also related to Rudhal Shah versus State of Bihar. This case is also related to the sovereign immunity, or let us say, torts committed by the state, right? And Kasturi Lal versus State of UP. In Kasturi Lal versus State of UP, Supreme Court told that, the court told that, if police is committing any act, the state will not be liable, which means for the torts committed by its employees, the state shall not be liable. So Kasturi Lal's judgment was of course overruled. So in Neelabati Behra versus State of Odisha, Supreme Court told that even if you are exercising sovereign function, you will not have any immunity if fundamental rights are violated. Is this clear? I think yes. Next, directive principles are Nirdeshaka Sutralu. So directive principles of state policy, it is in Telugu it is written as Rajya Adeshika Sutralu, but here it is written as Nirdeshaka Sutralu. Okay, whatever it is. What is directive principle? Well done Alpha. Excellent guys. So the answer is directive principles are not justiciable. It means that if directive principles are not enforced, you cannot go to the court, right? So DPSP is enforced అయితే court kelli case file cheyaladu, but they are fundamental in the governance of the country. Very good Madhavi. So ఎప్పుడైతే గవర్నమెంట్ ఒక పాలసీ తయారు చేయాలనుకుంటారో, సో ఎట్ దట్ పర్టికులర్ పాయింట్ ఇన్ టైం దే విల్ లుక్ ఎట్ ద డైరెక్టివ్ ప్రిన్సిపల్స్. సో డిపిఎస్పీలో ఉన్న పాలసీని మనం ఎన్ఫోర్స్ చేస్తున్నామా, దే ఆర్ ఫండమెంటల్, బట్ ఈవెన్ ఇఫ్ దే ఆర్ నాట్ ఎన్ఫోర్స్డ్ యూ కెనాట్ అప్రోచ్ ద కోర్ట్. వెల్ డన్ ఆల్ఫా, మాధవి అండ్ ఘానియా. Very good guys. Let's proceed with the next question. Defamation for which damages are claimed will be part of the law of, only those who read the question properly will be able to answer it. Defamation for which damages are claimed, పరువు నష్టం జరిగినందుకు నష్టపరిహారం అడిగే హక్కు ఏ చట్టంలో వస్తుంది? What is your answer guys? Alpha says 2 torts. Madhavi says it's 3 contracts. Naik says it's 2. Nidhi says it's 2. Ghania it's 2. Yes, very good guys. So the answer is torts. Okay. See, in defamation there are 2 types of defamation, right? So now in Rahul Gandhi's case, it is a criminal defamation. That is why he was sent to jail, right? So when it is a civil defamation, you will claim damages. So damages ante nashta pariharam. You will ask the party to pay some money, or you will ask him to unpublish or do something, right? So that is damages. Damages can be claimed in torts. Okay, whereas punishment is given in crimes. Is this clear? Because damages are of civil nature, right? Damages are awarded in civil cases. Punishment and fine is awarded in criminal cases. Sometimes compensation is awarded in criminal cases also. But just remember that. Now if I ask defamation for which punishment is sought, let me reframe the question a bit. If I reframe the question as to defamation for which punishment is sought as a remedy, then it will be a part of defamation for which punishment is sought as a remedy, then it will be a part of. So it will be a part of criminal law, that is crimes, right? So that is what. Next. I think we discussed this yesterday, right? Like 48A. 48A of the Constitution deals with. Just give me a minute, guys. I'll just drink some water and come. I think the light doesn't go over. I'll be back in a while, okay? What is the answer? I think I have to adjust my seat a bit. This can be the correct position. Yeah. What is the answer, guys? Okay, let me look at the question first. Oh my gosh. Yeah, here it is. Okay. Yeah. So the answer is actually 3. Now 48 falls under which law? 48 falls under DPSP, because in DPSP, whether DPSP is a right or duty. DPSP is a right or duty. DPSP is duty. DPSP is whose duty? It is the state's duty. So under Article 48A, it is a duty of the state to preserve and protect and to improve the environment. It's not the right of citizen, right? It is not state's right. It is not citizens' duty. Citizens' duty is there in fundamental duties, right? But not here in 48A, which is a DPSP, right? Next. 75. Who among the following takes a decision whether a bill introduced in state legislative assembly is money bill or not? రాష్ట్ర శాసనసభలో ప్రవేశపెట్టిన బిల్లు ద్రవ్య బిల్లు అవునా కాదా అనే నిర్ణయాన్ని క్రింది వారిలో ఎవరు తీసుకుంటారు? వెల్ డన్, వెరీ గుడ్, వెరీ గుడ్. Alpha, Nidhi, Ghania, very good. So the answer is speaker, right? Money bills are introduced with the prior permission of. Money bills are introduced with the prior permission of whom? The answer is correct, but yeah. Okay. Money bills are introduced with the prior permission of. So in a state, yeah, president or governor. If it is in the Lok Sabha, you have to take the permission of president. If it is in the assembly, then it has to be the permission of governor, right? But who will certify whether a bill is money bill or not? That is the speaker, right? Speaker will certify, అంటే స్పీకర్ ఇది మనీ బిల్లా కాదా అనేది స్పీకర్ డిసైడ్ చేస్తాడు. కానీ అసలు ఇంట్రడ్యూస్ చేయడానికి ఫస్ట్ యూ హ్యావ్ టు గెట్ ద పర్మిషన్ ఫ్రమ్ ప్రెసిడెంట్ ఆర్ గవర్నర్, రైట్? దట్ ఈస్ ఇంపార్టెంట్. Because sometimes what happens is people who don't study, they'll think that it is finance minister, right? So you will be answering that. So just take a note of this. Next, the transfer of, very important. Yesterday I made a reference to this. The transfer of specific interest in immovable property as a security for repayment of loan is called స్థిరాస్తిపై నిర్దిష్ట హక్కును రుణం తిరిగి చెల్లించేందుకు భద్రతగా బదిలీ చేయడాన్ని డాష్ అంటారు. Well done, excellent, very good guys, Nidhi and Madhavi. So yesterday I talked about, very good, Alpha, Nayak, Indira, very good guys. If it is movable property, what is the option? If it is movable property, we call it as a pledge. If it is immovable property, then it is known as mortgage, right? That is it. And the right to hold possession, okay, so the right to hold possession of whether this particular movable or immovable property, what do you call that? So now for example I transferred my immovable property to you, and you will hold the possession of it, right? So what is that right known as? Yesterday I talked about it in my class. But don't just watch the session and leave, okay? Make notes out of it so that you will not remember, you will not forget it in the next class. I talked about right to lien, LIEN. Do you remember this? The right of lien is having the possession of, yes, having the possession of the property like until the debt is repaid back, right? That is really important. Next, factual question. When was Universal Declaration of Human Rights adopted by UN? ఐక్యరాజ్య సమితి మానవ హక్కుల సార్వత్రిక ప్రకటనను ఎప్పుడు ఆమోదించింది? ఎప్పుడు? Write it down in the chat window. Very quickly guys. So actually I did not get the link for 5 p.m. session. I think I have to check with my team whether they have made it ready or not. Well, where is the answer guys? Okay, Indira says it's 1. How about others? What is your option? No idea. Guess something, no? See, even if you have no idea, like type something, because there's no negative marking even in the actual exam. So you should not actually worry about it, right? So the answer is 10th December 1948. Okay, 10th December 1948, Universal Declaration of Human Rights was adopted by the United Nations. Next, very important question. Shah Banu Begum and Shaira Banu are the women who were successful in empowerment of Muslim women in the matters of dash and dash respectively. Very easy questions, I would say. Very good Alpha, very good. See, there is a case. Well done Nayak, Nidhi. Muhammad Ahmad Khan versus Shah Banu Begum, Shaira Banu versus Union of India. I think this is coming on my back or what? Is this coming on my back? Okay, anyways, let me just write it down. So in Muhammad Ahmad Khan versus Shah Banu Begum, So the case was that Muslim women are entitled to maintenance from the husband. So that is Shah Banu. Whereas Shaira Banu is a recent case, in which instant triple talaq, right? So talaq so that was struck down as null and void by the Supreme Court. So instantaneous triple talaq is like if husband gives talaq 3 times, so talaq is divorce, right? So if he says thrice talaq, 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 the divorce is granted. But Supreme Court told that this is unconstitutional, as a result of which Parliament has enacted a very important legislation, that is the Muslim Women Protection of Rights on Marriage Act. The Muslim Women Protection of Rights on Marriage Act. This particular act, right? So this particular act has granted, according to this particular act, this instantaneous triple talaq is now invalid. It is illegal. I hope this is clear, right? Next question. Did I miss the chat? Yeah. Dash means wrong because it is prohibited. What is wrong? It is wrong because it is prohibited. Dash ante tappu endukante idi nishedhinchabadindi. I think I actually discussed this in legal maxims. Very good, Alpha. Excellent. Very good, Nayak. Very good, Nidhi. So the answer is mala prohibita. So what is the meaning of mala prohibita? So mala is a wrong, right? Mala or malice is wrong. So mala prohibita, it is wrong because it is prohibited. Like I gave you an example. For example, this is a road, right? So going on left side of the road, it is wrong only because it is prohibited, right? So going on right side of the road, sorry, for example, in India, if you go in the US, we go on the left side, on the right side of the road. But when it comes to rape or murder, so these kind of things, whether you prohibit or not, whether it is India, US, or whether you prohibit or not, it is wrong in itself, right? So committing rape, that means having an intercourse with somebody without their consent is definitely a wrong, right? Killing somebody is definitely a wrong. So though that is known as mala in se, right? It is a wrong in itself, mala in se. Whereas mala prohibita is, it is prohibited because law is prohibiting. It is a wrong because law is prohibiting it. So you know what is actus reus and what is mens rea. So mens rea is guilty mind and actus reus is wrong action or guilty act. Okay, next. Finance Commission is constituted by the President of India for every Finance Commission is ఆర్థిక సంఘం భారత రాష్ట్రపతి చే ఎన్ని సంవత్సరాలకు ఏర్పాటు చేయబడుతుంది? What is the answer? For every 5 years, right? Very good, Indira, Ghania, for every 5 years. So Finance Commission, okay, is a constitutional body under Article 280 of the Indian Constitution, right? Under Article 280, it is a constitutional body which is appointed by the President will form a Finance Commission, and so this commission will submit its report every year to the President, right? So it is constituted for every 5 years. So just remember that for whatever the advice is given by Finance Commission, it is actually not binding on the President or the Parliament. These are just advisory in nature, whatever are the recommendations given by Finance Commission. An agreement which is enforceable by law at the option of others is known as. An agreement which is enforceable by law at the option of others is known as. Oh, okay. I think most of you are actually getting it wrong. So what is the answer? See, what do you mean by agreement that is enforceable at the option of other party? So it means it is based on the wish of other party. So ఒకరి ఇష్టంతో చట్ట ప్రకారం అమలయ్యే ఒప్పందం, that is a voidable contract, right? Now let me explain you what is void, voidable and valid contract. First, void and valid are very simple, right? Void ante chelladu, shunyam. Void ante shunyam, sunna, not valid. Valid ante yes, it is enforceable in a court of law. Void ki valid ki madhyalo undedi, it is voidable. So when a contract becomes voidable, right? So when a contract becomes voidable, a contract becomes voidable when the consent is obtained by let us say fraud, extortion, sorry, not extortion, coercion, force, undue influence. So it under free consent level. So for example, undue influence, if I talk, don't worry if you don't understand these terms, I'll explain it in contract law. So undue influence is like, for example, father and son will have an undue influence, right? So if father says something, whether it is correct or not, the son will sometimes he'll have to obey those things. So somebody will come and say that, ask your father to do, and he'll sign an agreement. Now son's consent is not there. Just because his father is saying, he's signing it. At this particular point in time, whose consent was not free, ఎవరి consent అయితే ఫ్రీగా లేదో వాళ్ళ ఇష్టం అది ఎన్ఫోర్స్ చేయాలా చేయొద్దని. In this case, son will decide whether the contract has to be enforced or not. Okay. So however, we will discuss about these aspects in contract law. I'll talk in detail like what is a valid, void and voidable agreement. Next question. Right to private defense is private rakshana hakku is available under all circumstances. Number అన్ని పరిస్థితులు అందుబాటులో ఉంటుంది. Number 2, available where there is time to have recourse to the protection of public authority. What is the answer? Just give it down in the chat window. If I switch off my bit sometime. Answer it, guys. Just well done, Nidhi. Sorry. Yeah, Nidhi and Alpha. I think most of you got this correct. So it means that when no public authority is there to help you, right? For example, oh my gosh, why this is opening? Yeah. Available when there is no time to have recourse to the protection of public authorities. Like for example, let us say you are in a forest, or you are somewhere, you are in Nallakunta only. Let us suppose that you are in Hyderabad only, and you know, just a second, and you are actually there over here, and somebody comes and points a gun to you, towards you. Now, when somebody points a gun, towards you, so will you take your phone out and call the police and say, "Hi, police! Like somebody is pointing a gun towards me. Come and save me." Like, will you be in a position to do that when somebody points a gun on your head? You won't be able to do that, right? So immediately you have to defend yourself. Like maybe you point the gun towards him, or take a stone, or take something and make sure that he's not killing you. So by the time you take and make the call, he'll kill you, right? So when there is no time to get the protection of public authorities, at that particular time you will definitely have the right to private defense. Okay, next. Who protects the intellectual property in paintings created by artists? కళాకారులు రూపొందించిన చిత్రాలలో మేధో సంపత్తిని ఏది రక్షిస్తుంది? Check it, guys, check it. Very good, Indira, excellent. The answer is copyright, right? So copyright is available for any work that is created by a person. I mean, work in the sense, like for example, your writings or your songs, your movies, your paintings, your podcasts, whatever it is. Over this you will be having intellectual property, that is copyright. Geographical indication is given in cases. I will clear it today, Alpha, don't worry. So geographical indication is given for something which is specific to a geographical region. So it tag another region kostadi manishiki kaadu. Like for example, the laddu in Tirupati, let us say, it has geographical indication. For example, Hyderabad Halim. Okay, and there is some laddu in Tamil Nadu, which is made up of not laddu, it is a chikki. No, it is not some. There's a different name for it. So, oka area ki sambandhinchina daniki, if you give a indication, that is a geographical indication. Patents are given for inventions. Okay, like for example, I have invented this web camera. Okay, that is a patent. I have invented a chip in my laptop, or I have invented a laptop, then I'll get a patent for it. I invented a fan, I'll get a patent for it. Okay, I invented this pen tablet, I'll get a patent for it. Whereas copyright is given for something that is created by you. I mean, it is not an invention, it is a creation, right? So you write a book, or you make some drawing, or you sing a song, all of these falls under copyright. Is this clear, Alpha? Or there is still confusion? Designs is nothing actually. So there is something known as industrial design, which is given as for the goods that are manufactured at a higher scale. So about which we'll talk in IPR chapter. Very good, Alpha, excellent. Another question. So now I think you should be able to answer this, right? If a company develops a new technology, right? A company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention? Now you should be in a position to answer this. Very good, Nidhi. Excellent. Very good, Indira. Very good, Madhavi. Okay, so when you are developing a new technology, you will get a patent for the technology. So when you have a patent, nobody else will be able to use it without your permission, right? Guys, next. The money or property given or agreed to be given by bridegroom to his bride in a Muslim marriage is what? ముస్లిం వివాహంలో వరుడు తన వధువుకు ఇచ్చిన లేదా ఇవ్వడానికి అంగీకరించిన డబ్బు లేదా ఆస్తిని ఏమంటారు? వెరీ గుడ్. సో ద ఆన్సర్ ఇస్ మెహర్. సో మెహర్ can sometimes be fixed and sometimes it can be a variable also, which means they can decide it after. So meher is, generally what happens in a dowry. So who gives dowry? Groom or bride? So generally in Hindu law, or so let's suppose in Hindu law, who gives dowry? So do you understand what is the dowry? Ante katnam. So katnam ichchedi evaru? Groom or bride? Right, bride will generally give in Hindu law, but in Muslim law there is a specific amount. It is not dowry again, right? So it is meher. It is a amount which the groom has to pay to the bride or will agree to pay. So that is known as meher. Okay, so meher is the right answer. It can be cash or kind. That means it can be this, that. Next. The convict, very easy question. The convict in Rajiv Gandhi assassination case, freed by the Supreme Court recently. The convict in Rajiv Gandhi assassination case was freed. Just give me a second, guys. I'll come back in a while. Answer the question in the chat window. I'll be back. Let me open the chat window. What is the answer, guys? Oh, I think there is some problem over here. Okay. So the answer is A.G. Perarivalan. So Perarivalan was a convict in this particular case, right? So in the Rajiv Gandhi assassination case, he was a main convict, and he was actually asked by the Supreme Court to release, right? Of course, other convicts along with him were also released. I think some problem in my screen. Why is this gap coming over? Okay, anyways, that shouldn't be a problem. Let me focus on the next question. Who among the following has a right to establish the bench of Supreme Court elsewhere in the country? So where is the bench of Supreme Court now? Where is the bench of Supreme Court now? Just a second. I think this has to be moved a little. Anyways, should be a big problem. Guys, just give me 1 second. I'll just try to check this out. What exactly is the problem? This side or that side? I think now it's okay. Okay, what is your answer? Who among the following has the right to establish the bench of Supreme Court elsewhere in the country? Very good, Nidhi. Excellent. Sorry, Alpha. Very good. So the President of India can establish, so under Article 130, right? So only the Chief Justice of India can recommend the President to establish a new bench, right? So with the recommendation of Chief Justice, the President will actually appoint a bench under Article 130. Right. So it actually means no other court. Oh, so what? Is my screen all right? Just a second, guys. I think there's no thought. Yes. In this one, I'm seeing a lot of. Okay. Okay. Next. So currently, what is the where is the Supreme Court seat and bench? So Supreme Court has its seat in Delhi, right? So if you want to establish a newer one, so it has to be with the approval. CJI will have to recommend it and then President will approve. Yeah, next. Who among the following was the first chairperson of National Commission for Women? కింది వారిలో జాతీయ మహిళా కమిషన్ మొదటి చైర్పర్సన్ ఎవరు? జాతీయ మహిళా కమిషన్ మొదటి చైర్పర్సన్ ఎవరు? No, actually. What do you think is the answer, guys? So the answer is Jayanti Patnaik. So Jayanti Patnaik was the first women chairperson of National Commission for Women. So National Commission for Women, is it a constitutional body? National Commission of Women, it is not a constitutional body, it is a statutory body. Very important question, look at this. The famous English case Reliance versus Fletcher has laid down the principle of, I actually discussed about it, right? The famous English case of Reliance versus Fletcher has laid down the principle of Alpha says it's for Reliance versus Fletcher. I talked about this case, right, like very recently. There was an independent contractor. Very good, Nidhi, excellent. So the answer is strict liability. So the concept of strict liability was laid down in Reliance versus Fletcher, wherein it was told that whether your mistake is there or not, you will be held liable. Whereas for strict liability, there are some exceptions, right? So when there are no exceptions, strict liability plus no exceptions is equal to absolute liability. So absolute liability is a principle enunciated by Indian Supreme Court, right? So absolute liability is a principle enunciated by Indian Supreme Court. Next. The idea of a constituent assembly was put forward for the first time by. The idea of constituent assembly was put forward for the first time by. Very quickly, guys. So we have approached the last 10 questions of the day. Well done, Srikanth, Nidhi, Ghania. Excellent. So the answer is M.N. Roy or Manavendranath Roy. So he was the first person who put forth the concept of Constituent Assembly in India. The new Consumer Protection Act in India was made in the year. The new COPRA Act or Consumer Protection Act was made in which year? Okay. Very good, Alpha. Five. Oh my gosh, I think the options are given as like 5 over here, but it might be a continuation of options, I guess. So the answer is 2019. In 2019, the new Consumer Protection Act was enacted. Next, the ombudsman system to inquire into allegations of corruption by state government employees is called. Ombudsman to inquire. రాష్ట్ర ప్రభుత్వ ఉద్యోగుల అవినీతి ఆరోపణలపై విచారణకు నియమించిన ombudsman ఎవరు? What do you think is the answer? Very good, Srikanth. Excellent. Very good. Yeah. So the answer is Lokayukta. What is the concept of ombudsman? So ombudsman is somebody who looks into the grievances of public, right? So the concept of ombudsman was first introduced in Scandinavian countries like Norway, Sweden and Denmark. So in these Scandinavian countries, the concept of ombudsman was there. In India also we started to introduce at union level. There is Lokpal. So Lokpal looks into the corruption allegations of central government employees, whereas Lokayukta looks into the corruption allegations of state government employees. Next question. Very important question, guys. The case of Air India versus Nargesh Mirza relating to termination of service. Let me move myself a bit. Yeah. Termination of service on ground of first pregnancy is an example of Air India. Just a second. Yeah, I think this is correct. Position. Yeah, Air India versus Nargesh Mirza తీర్పు అనగా మొదటి గర్భం కారణంగా సర్వీస్ రద్దుకు సంబంధించే కేసులు దీనికి ఒక అద్భుతమైన ఉదాహరణ. Just answer it down in the chat window. So I became so small. What is the answer, guys? Very quickly in the chat window. Acting under dictation. Okay. How about other options? Like how about other students? What are your options? Right. Okay, guys. So the answer is unreasonableness. Right. So I'll tell you about this particular thing. What is this unreasonableness? Let me actually reduce my size a bit. Okay. Yeah. So Air India has certain conditions, like for their women employees, right? You have to leave the service. Number one, if you get 35 years of age. Okay. Number two, if you are married. And number three, if you are first pregnant. Like when once you get pregnancy, your service will be terminated in Air India. Okay. So Supreme Court has struck down all of these rules and told that this is unreasonable. Okay, so there is no reasonable justification for this particular thing. So that is what was upheld in Air India versus Nargesh Mishra. Mirza, Merza. Next, in electronic contracts, B2C denotes. Not a difficult question, so to speak. B2C, what is the meaning of B2C? I think my size is perfect over here. Like I need not actually cover the entire screen. Okay. Yeah. Give me your answer, guys. What do you think is the answer? B2C is known as business to customer, right? Okay. Sorry guys, there is some problem due to which I became like this. How do I change this? Okay, just listen to this, right? I have to adjust it in the, yeah. So in business, right? So in business, there are certain things like, for example, B2C, right? So B2C is business to customer. D2C is direct to customer. So in business to customer, right? Just a second. Adjustment has to be done. Yeah, this is like perfect. Okay, so I don't want to disturb it now because it is actually taking much. Okay, see, B2C is from business to customer, right? So business to customer means like a product is coming from the business to the customer. So in between there are certain people who are delivering, right? For example, there is Coca-Cola. So Coca-Cola, it will not come directly from the factory to your home, right? So it is there in the factory, then it comes to dealers and distributors, they will release it in the retail stores, and from there you will get it. Whereas in D2C is a new kind of consumer facing brands. So here you will get it directly from the, directly from the business, directly from the factory, I would say. Like for example, if you order anything from Amazon, right? So then you are getting it directly from the seller, like directly from the factory or wherever it is there. So here we have actually removed the concept of middleman. Then we have the concept of B2B. So B2B is business to business, right? So for example, if you are somebody, you are delivering, let us say a soap to wash the dishes or to clean the utensils. If you are delivering it to a hotel, right, it is a part of your B2B business. If you are delivering it same to the house, if you are selling it to a household, then it is a part of your B2C business. So that is what you have to remember. Now, as per the Juvenile Justice Care and Protection of Children Act 2015, which of the following children can be kept in special homes? who can be kept in special homes. జువెనైల్ జస్టిస్ పిల్లల సంరక్షణ మరియు రక్షణ యాక్ట్ 2015 ప్రకారం కింది వాటిలో ఏ పిల్లలను ప్రత్యేక గృహాల్లో ఉంచవచ్చు? ప్రత్యేక గృహాలు. What is the answer, guys? Very quickly. What do you think is the answer? So the answer is child in conflict with law. Who is a child in conflict with law? A child who is below the age of 18. Very good, Nidhi. A child who is below the age of 18 is known as a child who is conflict with law. So those people you can take and keep them in the shelter homes, special homes. Which of the following punishments is not prescribed under the IPC? Which of the following punishments is not prescribed under the IPC? Very good, Nidhi. Excellent. So the answer is transportation from India. Very good, Alpha. Excellent. Well done, well done. So, very good, Nayak. Very good, Srikanth. Death sentence is there. Life imprisonment is there. Fine is also there. Right. So, the only thing, transportation, if you are committing any crime, we won't throw you out of India at any cost. So, that is what is not prescribed under IPC. Next, question number 97. So we'll discuss 8, 9 and 100. 3 more questions for the day, guys. We'll leave. In India, prenatal sex determination of an unborn child is legally allowed when women already has what? Read the options. Right. భారతదేశంలో పుట్టబోయే బిడ్డ యొక్క జనన పూర్వ లింగ నిర్ధారణ చట్టబద్ధంగా allowed, not allowed at all. Game X Alpha. Srikanth says 3. What do you think will be the answer? What do you think, guys? So the answer is not allowed at all, not allowed whatsoever. So prenatal sex determination is definitely not allowed, right? So even when there are fetal abnormalities, just give me a second. Even when there are fetal abnormalities, matlab when the fetus is actually not developed completely, right? So fetus is not developed completely, or there is some genetic problem, so then we won't tell you the sex, okay? So this is male or female, we won't tell you. So there doctors might decide about the further action, whether we have to that is what I'm explaining now, Srikanth. So when there are fetal abnormalities and genetic defects which are suspected, there we will tell like whether we have to deliver the baby or not, but we are not going to determine the sex, right? The question is whether prenatal sex determination is allowed or not, right? In this particular case, anything might happen. We are not going to determine the sex whatsoever. So if there are abnormalities, we'll decide whether we have to remove the baby or we have to give it, but we are not going to determine the sex. Is it clear for you, Srikanth? No, it's okay, not a problem. So నేనేమంటున్నా అంటే పిండం అసాధారణతలు మరియు జన్యుపరమైన లోపాలు ఉన్నప్పటికీ, సో ఇవి ఉన్నా కానీ మనం సెక్స్ డిటర్మినేషన్ చేయము. సో ఇక్కడ ఏంటంటే లింగ నిర్ధారణ గురించి మాట్లాడుతున్నాం కదా. సో లింగాన్ని ముందే నిర్ధారించము అంటే సెక్స్ని ముందే డిటర్మైన్ చేయము అంటే ముందే వీ విల్ నాట్ కమ్యూనికేట్ ఇట్ టు ద పేరెంట్స్ ఆర్ ఎనీబడి. ఒకవేళ ఏదైనా ప్రాబ్లం ఉంటే వీ విల్ డిసైడ్ వెదర్ వీ హ్యావ్ టు డెలివర్ ద బేబీ ఆర్ వీ హ్యావ్ టు లైక్ we need not deliver the baby. That will be deciding, but it's not about determining the sex. Next, in which landmark judgment did the Supreme Court of India lay down the basic structure theory? భారత సర్వోన్నత న్యాయస్థానం ఏ మైలురాయి తీర్పులో మౌలిక అంశాలు లేదా నిర్మాణ సిద్ధాంతాన్ని నిర్దేశించింది? వెరీ ఇంపార్టెంట్ అండ్ ఈజీ క్వశ్చన్. Keshwanand Bharati versus State of Kerala, judgment delivered on 24th April 1973 by a 13-judge constitutional bench. Right. So, in Keshwanand Bharati case, Supreme Court told that basic structure cannot be violated, cannot be struck down, cannot be diluted whatsoever. Right. In Golaknath case, Supreme Court told that fundamental rights cannot be amended. In Keshwanand Bharati, Supreme Court told yes they can be amended, but you cannot touch this. S.R. Bommai versus Union of India, secularism was held a part of basic structure. In I.R. Coelho versus State of Tamil Nadu, Supreme Court told that basic structure cannot be diluted again. So Keshwanand Bharati case is applicable from 24th of April 1973. Next, which American Supreme Court judgment relating to right to privacy of a woman relating to abortion has been overruled in June 2022? Abortion సంబంధించి మహిళా గోప్యత హక్కుకు సంబంధించిన ఏ అమెరికన్ సుప్రీం కోర్టు తీర్పు జూన్ 2022లో రద్దు చేయబడింది? సో గైస్ ఈ క్వశ్చన్ చూసిన తర్వాత మీకు అర్థం కావాల్సిన విషయం ఏంటంటే so you have to follow current affairs at least till April 2023, right? Because last year exam happened on July 21st, July 21, 2022. June lo jarigina issue gurinchi he asked a question. Of course ee case paata case hai, okay? So Roe versus Wade ane paadi. The question is which judgment was overruled, right? So ee judgment we have overruled this in 2022, in June 2022. So till April also, the current affairs are really, really important from August till April. Okay. So in Roe versus Wade, American Supreme Court told that abortion is completely legal. It is related to privacy of women, whether the woman wants to adopt a child or not. So recently there was a case like careful parenting versus some other party. In that particular case, this Roe versus Wade was overruled, right? So Marbury versus Madison is a very, very important case with respect to judicial review, because for the first time a law made by the Congress was struck down by the American Supreme Court. మొదటిసారి అమెరికన్ కాంగ్రెస్ తయారు చేసినటువంటి చట్టాన్ని మార్బరీ వర్సెస్ మాడిసన్ కేసులో కొట్టివేయడం జరిగింది. So there the concept of judicial review was evolved, right? So these two are really, Marbury versus Madison is a really important case, I would say. Last question of the day, guys. 100. Sorry, I think we'll deal with 110 questions, I guess, right? Okay. In which of the following case the Supreme Court decriminalized adultery by striking down section 497 of IPC? నిన్ననే డిస్కస్ చేసిన క్లాస్లో. I discussed it in yesterday's class. I think I have to install a light. I got my light. Very good, Nidhi. So the answer is Joseph Stein versus Union of India, case of 2018. Right. So Young Indian Lawyers Association versus Union of State of Kerala. This is related to the Sabarimala case. Right. So yesterday I talked like what exactly is adultery. Right. So just watch the previous video if you did not watch. Of course, when I'm discussing criminal law, I'll talk about adultery in a greater detail again. Next, 101. Which of the following is not a cyber crime? I want very quick answers. Which of the following is not a cyber crime? I think from tomorrow I have to actually place a water bottle in this room because I don't want to go there to get the water in between all the time. What is the answer, guys? Which of the following is not a cybercrime? Very quickly. Very good, very good. Very good, Nidhi, excellent. Okay, if plagiarism is not a cybercrime, what is it? Supplementary question. Very good, Srikanth, very good, Nayak. Hacking, phishing, and denial of service attack. Hacking, phishing, and denial of service attack. I explained like all of these three in yesterday's class, right? So, what is plagiarism? Plagiarism is copying something, right? So, for example, I asked you to write a research paper, but what did you do? You have copied it from somewhere else. Yeah, you are a little close to it, Nidhi. So, plagiarism is violation of copyright or violation of intellectual property right. It is not a cyber crime, right? Copyright is an IPR. It is an intellectual property right. Very good, Nidhi. Excellent. 102. What is the full form of GST? GST. Yeah, very good. I think perhaps one of the most easiest questions, I would say. Very good, Nidish, Srikanth, Nayak. Very good guess. The answer is goods and service tax. By enacting 101 amendment, we have introduced GST in India. So before introduction of GST, we were having multiple taxes at the state and also at the union level. Next. An employee of a public or private organization who exposes certain irregularities in such organizations in larger public interest to the higher authorities can be called ఒక పబ్లిక్ లేదా ప్రైవేట్ సంస్థ యొక్క ఉద్యోగి అటువంటి సంస్థలోని కొన్ని అవకతవకలను అధిక ప్రజా ప్రయోజనాల కోసం ఉన్నతాధికారులకు బహిర్గతం చేస్తే వారిని డాష్ అని పిలుస్తారు. Very good, Nidhi. Excellent. So the answer is whistleblower, right? So it can happen either in government or even in private sector. Like you are exposing the irregularities that are happening. Like for example, you might have heard about this IAS officer whose name is Ashok Khemka. I think he is a Rajasthan cadre IAS officer. So he is a very famous whistleblower. Wherever he goes, like he will be transferred very quickly from there. So because he is very brutally honest and he exposes things out, right? So that is what is known as whistleblower. Next, the law which governs the disputes among nationals of different countries is called. వివిధ దేశాల జాతీయుల మధ్య వివాదాలను నియంత్రించే చట్టాన్ని ఏమంటారు? Very quickly guys, please give me your answer in the chat window. Whistleblowers. I think in YouTube it will take some time for me also for the answers to get reflected over there. Srikanth says it is 4. No, Srikanth. So the answer is 3. Private international law. So among nationals of different countries. రెండు దేశాల మధ్య కాదు, రెండు దేశాల మధ్య ఉన్న మనుషుల గురించి. సో జాతీయులు అంటే మనుషులు అన్నట్టు. లైక్ ఫర్ ఎగ్జాంపుల్ ఐఎమ్ ఇన్ ఇండియా, నేను ఇండియాలో ఉన్నా, అండ్ ఫర్ ఎగ్జాంపుల్ శ్రీకాంత్ ఈజ్ ఇన్ యుఎస్ఏ. మా ఇద్దరి మధ్యలో ఏదైనా కాన్ఫ్లిక్ట్ ఉంటే, డిస్ప్యూట్ ఉంటే, ఇట్ ఈస్ సాల్వ్ అండర్ ప్రైవేట్ ఇంటర్నేషనల్ లా. ఒకవేళ రెండు దేశాల మధ్యలో ఉంటే సో దెన్ ఇట్ ఈస్ పబ్లిక్ ఇంటర్నేషనల్ లా. ఇఫ్ ఇట్ ఈస్ బిట్వీన్ టూ కంట్రీస్ then it is public international law. If it is between two individuals of different countries, then it is private international law. Is this clear, Srikanth? Very good. Next, which of the following, very good Srikanth, which of the following offences was not included in the Indian Penal Code after the Nirbhaya incident in 2012? నిర్భయ ఇన్సిడెంట్ ఘటన జరిగిన తర్వాత క్రింది వాటిలో ఏ నేరాలను భారతీయ శిక్షా స్మృతిలో ప్రవేశపెట్టలేదు? కొంచెం జల్దీ ఆన్సర్స్, గివ్ మీ వెరీ క్విక్ ఆన్సర్స్ నౌ. Guys, please, last 5 questions, just give me the answers. Whether it is correct or not, it is immaterial. Just tell me something so that at least I'll have some idea that you are not sleeping in the class. Right, so the answer is custodial rape. Okay, so custodial rape is a case where you are under the custody. Like, let us say for example you are A, right, and you are there in the custody of your father or maybe guardianship of somebody else. So here if rape is happening, then this is not included in IPC. This was already there, right? So voyeurism is actually when somebody is having sex, okay, you are going and recording it, or when somebody is you are actually recording somebody's private parts. Somebody is bathing and you are recording it. That is known as voyeurism. So stalking is you are going behind a woman, you are looking at her, you are staring at her and you are trying to approach her. Okay, so this falls under stalking. Sexual harassment is you are harassing someone sexually, so that is sexual harassment. All of these things are included, but custodial rape is not introduced after the Nirbhaya incident. Right. Next, 106. Which committee was appointed to look into the demand for separate statehood of Telangana? తెలంగాణకు ప్రత్యేక రాష్ట్ర ఏర్పాటు డిమాండ్ను పరిశీలించేందుకు ఏ కమిటీని నియమించారు? Very easy question, guys. I think it is really, really easy. Very good. So the answer is Sri Krishna Committee. So Sri Krishna Committee gave its recommendations for the separate state of Telangana. So this was appointed, but however, we are in Telangana right now. Next, the term taking cognizance used in criminal law means. Criminal law lo upayoginchina taking cognizance ane padaniki ardham enti? Very good, very good. Nayak, Srikanth, Indira. Taking cognizance. Very good, Nidhi. So the answer is taking notice of the matter judicially. So it means that when it comes to the court will say that taking cognizance of the facts of this particular case, we are admitting this particular matter or we are rejecting. Whereas when judiciary is taking this particular matter, then we call it as taking cognizance. Next, 108. Lakshadweep is under the jurisdiction of which High Court? Very easy question. I think we made a passing reference to it in yesterday's class. లక్షద్వీప్ ఏ హైకోర్టు పరిధిలో ఉంది? Very good, Srikanth. So the answer is Kerala High Court. Lakshadweep falls under Kerala High Court. Last question of the day, perhaps, sorry. Last two questions. List match 1 and match 2. Power of President to promulgate ordinances. What is the answer for this? Power of President to promulgate ordinances is there under Article 123. So 1 is C. Right. Right to life and personal liberty is there under right to 21. Uniform Civil Code is there under 44. 3 is B. Right. And 4, appointment of Supreme Court judges under Article 124, that is A. So C, D, B and A. 3 is the right answer. Yeah. Which cannot be done directly, cannot be done indirectly. This statement emphasizes the doctrine of which cannot be done directly, cannot be done indirectly. ఇది నేరుగా చేయలేము, పరోక్షంగా చేయలేము. ఈ ప్రకటన యొక్క సిద్ధాంతాన్ని you call it as colorable legislation, which means if you cannot enforce, if you cannot make a law directly, you cannot actually make it indirectly. Like for example, there is a list, right? There is state list, central list and concurrent list. So if central government wants to make something on state law, so indirectly by using some subject on concurrent list you cannot do. So only if you can do directly it can be done. Otherwise indirect legislations are not possible, right? So doctrine of pith and substance is also important. So it talks about the substance of the law. And along with this, doctrine of eclipse is also really important, like when it comes to Article 13. So if a part of law is void, right? So let us say this is the law and only 2 sections of the law are void. ఒక మొత్తం లాలో రెండు సెక్షన్స్ తప్పు ఉంటే ఓన్లీ ఈ 2 సెక్షన్స్ మాత్రమే we will struck it as void, not the entire law. Entire law we are not going to cancel, right? Next comes the passage based questions. So mostly we will discuss passage based questions all together in a different class, right? So first of all, I'm really happy that you guys came here even on a important day. So you took time out for learning. So I'm really happy for that. And tomorrow I'll continue the class. And I think most probably we won't have a class at 5 o'clock because I did not get the stream key and the link. So let me just see if it is there. I'll take it. Otherwise not. I'll just update you in the group. Okay. So thank you for joining. Please like the session if you have enjoyed it, and also subscribe to the channel for regular updates. Okay. So I'm looking forward to seeing you all tomorrow in my class at 2 p.m. We will have a class. Tomorrow at 5 p.m. for sure we'll be having a class. Right. So I'll see you tomorrow. Bye bye.